Invents. Safe travels.
Yep, that's correct clock now.
Oh, they got the,
Yes, just not him.
We corrected it.
on the, on the first day that the clock is actually accurate, I picked to be a couple minutes late. Can't believe that. Welcome everyone to our meeting today. Thank you all for your attendance. And as you see, I just got back from an appointment and expecting to find my agenda right on the front of my desk. So I need to borrow an agenda. Thank you, thank you. Okay, we have the reading of the meeting minutes of November 5th, both public and executive. Are there any corrections or changes to the minutes?
Mr. Chair, I move that the commission adopt the meetings minutes, both public and executive, from November 5th.
I second it.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. We have the consent agenda. Is any
Now you have 2 more minutes.
Oh, 2 more minutes, I do, that's true. I'm in too much of a hurry, thank you. Slow down, Dallas. November 14th, public and executive sessions. Any changes or corrections?
Move we approve the minutes of the November 14th, public and executive.
Second the motion?
Is there any comment or discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions?
One
The motion-
abstention, Mr.
One
Chair.
abstention.
Yes, I was not here.
The motion carries. Okay, it's the consent agenda. Anybody wish to have an item taken off, or are we ready to go?
Move we adopt the consent agenda as presented?
I second it.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion carries. Okay, number 1 on the regular agenda is in the matter of the rules for the provision of telecommunications services. And PSC Regulation Docket 10 and 45. So we have proposed order number 9506 before us. Mr. O'Brien.
Thank you, Chairman, Commissioners. Bill O'Brien on behalf of Commission staff. What you have before you is proposed order number 9506, which would reopen 2 of the Commission's regulation dockets regarding the PSC oversight of telecommunications service providers. So that would be regulation docket numbers 10 and 45, which is a consolidated docket, and regulation docket number 41. And the reason for reopening those dockets would be to bring them up to date with a relatively new state law. Earlier this year, the legislature passed Senate Bill 18, which further reduced the Commission's authority over telecommunications service providers in Delaware. And that law was put into place to reflect recent FCC decisions regarding state authority over telecommunications providers. So what staff is proposing is that we amend regulation dockets number 10 and 45, which is codified at the administrative code at section 4001, and that we repeal regulation docket number 41, which is codified at the PSC's rules at section 4005. Those 2 moves would bring the rules up to date and consistent with the state law that was changed earlier this year. So what this opening order does is it directs the commission secretary to send the proposed changes to the Registrar of Regulations for publication in the Register of Regulations in accordance with the Administrative Procedures Act, and directs the secretary to publish the notice that's attached at the back of the order in 2 newspapers. It also sets a hearing date in front of the commission for February 26, 2020, and a deadline for public comments. This will bring the changes into compliance with the APA, and we ask that the commission pass 9506. I will say that we did circulate this to the incumbent carrier in Delaware, Verizon Delaware, and they had no objection to the proposed order. And we also had the input from the public advocate on this.
Thank you, Mr. O'Brien. Commissioners, any questions of Mr. O'Brien? Anybody else? Anybody else here to speak on this matter?
Happy to. Good afternoon, commissioners. For the record, Doug Smith, Vice President, State Government Affairs for the Mid-Atlantic States for Verizon. And it's been almost 20 years since I've last been here, but
I was going to ask how long it's been.
it's
right?
been 19 years since I've been in these hallowed
Wow.
halls, and it's a real pleasure to be back. They've given me the assignment for all Mid-Atlantic states for regulatory, so I'm thrilled to be working with this commission and staff again, so I'm looking forward to that. Regarding this particular order and draft amendments, Mr. O'Brien did an excellent job summarizing it. Verizon has reviewed it. We do recommend it for your consideration and ask for your approval.
Thank you, Mr. Smith, and welcome again.
Happy to be here.
Mr. Slater, any comments from you all?
Thank you, Chairman Winslow and Commissioners. Mr. O'Brien is correct. He did circulate the order to the public advocate, and our changes, corrections, questions have been incorporated. Thank you.
Thank you. Commissioners?
Move we adopt order number 9506 as presented.
I second.
Is there any discussion on the motion? Hearing none, all in favor signify by saying aye.
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 Are there any opposed? Any abstentions? The motion carries. Thanks again, Mr. Smith,
Thank you.
Thank you.
and you, Mr. O'Brien. Number 2 is in the matter of a provision of standard offers supplied to retail consumers in the service territory of Delmarva Power and Light Company. And Mr. O'Brien, are you on this one again?
No, sir.
Good afternoon, Chairman Winslow and Commissioners. Delmarva held its first tranche for the Delaware Standard Offer Service delivery year 2020 on Monday, December 2nd. I have here with me today Dr. Jim Letzelter from Liberty Consulting Group, who is the Commission's technical monitoring consultant, to review the market and present the results from this tranche 1. There are 2 versions of the presentation, a public and a confidential version. The confidential is detailed version of the bids. If you choose to view the confidential version, you will need to go into executive session with no live streaming. Here to give his presentation is Dr. Letzelter.
Good afternoon, Chairman Winslow and Commissioners. It's always a pleasure to be here.
Welcome.
Thank you. I have a presentation that should be up on the screen, please.
Mr. Chair, while we're getting prepared for the presentation, I'm going to ask each speaker to pull the mic directly in front of them. I happened to be online last week, and if you didn't have the mic right in front of you, you can't really hear what's going on. Okay, thanks.
Thank you. I noticed the same thing when I was reviewing a past video of that. Thank you. So Liberty Consulting has just completed its role as technical monitor for the DP&L December 2nd, 2019 Tranche 1 RFP for SOS. And if you could please go to the next slide, I'll summarize our findings. The auctions were the auctions were consistent with the RFP. They were competitive, and they had adequate participation and bid activity, and they resulted in prices that were consistent with changes in the market conditions. The PHI staff ran a good auction, did a very fine job, and as usual, it was supported through the NLX auction platform. Next slide, please. Our role, Liberty's role, has been to monitor the standard offer service RFP process, and that includes the following 6 areas: reviewing tasks and materials associated with communications, reviewing prospective bidder website access, monitoring eligibility and resolving any issues, confirming NLX's fees, and developing a power market assessment, setting opening prices, and then finally monitoring the actual auction and confirming results. Next slide. As an overview of Tranche 1, there were blocks of power procured for all customer classes. The residential and small commercial industrial, or risky class, had 4 blocks, each of 47.4 megawatts. Medium general service, MGS, had 2 blocks, each of 40.6 megawatts. Large general service, LGS, had one 15.1 megawatt block. And general service primary, GSP, had one 22.9 megawatt block. Next slide, please. This was the first year, the first tranche, in fact, in which the Delmarva risky class has been fully transitioned into 24-month blocks. Previously, 2017 and before that, all the contracts were for 36 months. In 2018, the transition began with just 12-month terms for new contracts. Then the new contracts in 2019 were a combination of 12 and 24 months. And now and beyond, in the future, all the risky contracts will be for 24 months until any such further changes is made. In any event, the transition went smoothly, and it's all set for the future. Did I skip one? Okay. Participation in Tranche 1 was very good. In fact, it's the highest it's been in the past 6 years. And this level of participation is conducive to a competitive bidding environment. As you can see, as compared to 2019, as a total year, we had more expressions of interest, or EOIs, from 10 to 12. We had more eligible bidders. It went up from 7 to 9. And we had more actual bidders. It went from 6 to 8. So, in fact, we have the highest number of bidders since 2016, and we actually had one more eligible who decided not to bid on bid day. So, participation is very good. Next slide. More participants typically leads to more bids, and that's what we saw. And you can see in the farthest 2 right columns the number of bids in 2019 and then in the 2020 procurement, which was this Monday's procurement. The risky blocks went from 14 to 21, from 10 to 15, and 8 to 15, and 8 to 12 in the consecutive blocks that were auctioned. For MGS, they also went up from 12 to 16 and 8 to 15. LGS, the number of bids more than doubled from 5 to 11, and in GSP, they went from 5 to 8. So this is all very positive. Next slide. Part of Liberty's role is taking a look at the market and providing an assessment to commission staff. And there are a number of things that we look to do with this. And the first is to identify and analyze any potentially adverse market conditions that could lead to a postponement of the auctions. We also use this to establish opening prices for the blocks for each of the customer classes. And then finally, we work with NLX to estimate the range of winning prices for each block. We concluded that there were no adverse market conditions and the auctions should proceed as scheduled. Next slide. In this slide, we take a look at the energy market. The key component of bids is the price of wholesale energy. The next most important is the price of capacity. So we'll start with energy. Wholesale energy market prices are lower in this last tranche than they were in both of last year's tranches. And I calculated average prices for a 1-year period and a 2-year period. And the one-year period average prices are 14% lower than in 2019 Tranche 1 and 17.1% lower than in Tranche 2. The two-year average prices are 11.5% lower than Tranche 1 and 14.8% lower than Tranche 2. So energy market prices are very low. They have been low. Last year they were considered low, and here they are a year later, you know, double-digit decreases lower. So it's pretty incredible. What's important is that the energy market prices are consistent with the decrease that we saw in gas prices, so we know that the market makes sense. And we'll talk a little about gas next slide, please. Natural gas prices for this tranche are lower than those from last year's Tranche 1 and Tranche 2 also. The one-year average prices are 14.6% lower than Tranche 1 last year and 22.5% lower than Tranche 2. The two-year average prices are 10.5% and 16.8% lower than Tranche 1 and 2 from last year, respectively. The gas is at historically low price levels. Every time I see a new price, it seems to be, wow, it just can't go any lower, yet it goes lower. So we're all enjoying that. Next slide, please. Just a word about gas and power correlation. Gas-fired units drive electric energy prices, setting the locational marginal price, or LMP, for the majority of hours in PJM, almost all of the peak hours, and not so much in the off-peak period, but gas prices certainly dictate what energy prices would be. DPL zone energy prices are graphed against Dominion South gas. I said DPL zone energy, electric energy prices are plotted against Dominion South gas prices, and you can see that they're fairly congruous. The peak for gas and electricity, both peaks that you see here are winter periods, and you see that gas is not peaking quite as high as electricity relative to the rest of the year. And the reason for that is electricity is a function of not just the gas price, but the efficiency of the units that are run. So while the gas prices are high during the winter, you're also calling on, throughout PJM, less efficient units, and it's causing the price to go up higher. So that summarizes the energy component. For capacity prices, next slide, please. All blocks in the 2020 RFP are subject to capacity prices for the 2020 and 21 delivery period. The risky blocks also take into consideration the 21 and 22 prices. Capacity prices are somewhat higher than last year, certainly lower than the year before, and higher prices in capacity serve to offset the benefits of the energy prices, but only slightly. Next slide. In conclusion, the market conditions indicated that Tranche 1 should proceed. The auctions were well run and were accomplished according to the RFP requirements. As usual, the NLX auction platform performed flawlessly. The auctions were competitive, and they resulted in winning bids that were consistent with the outlook for regional energy and capacity prices. So that concludes the public portion of my presentation, and I'm happy to entertain any questions.
Mr. Chair, thank you very much. I think it's good news based on how I interpreted it. One question I would have, though, is that we're buying now in 24 months periods, and with these prices this low, are we disadvantaging ourselves now? And well, how much have we lost by not staying at 3 years?
We may have gained a price advantage by going to 24. It really depends how the market will change going forward. There's no indication that prices are going to rebound and go higher again. So you can find some forward price projections and forecast price projections 3 years out, which I don't happen to have handy for the DPL zone, but you could look at what's going on 3 years out in terms of what's expected and compare that to the average of the next 2 years.
No further questions, Mr. Chair.
It seems that when the prices are low, we sort of wish, like Commissioner Gray, that maybe we bought in for 10 years. But as we all know, the prices do go up, and you don't want to be locked into a long-term period where the prices are high either. So we try to, I think, balance it. We made an adjustment and it seems like it's worked out pretty well. And I guess if there's a recommendation from staff to change that again at some point in time in the future, we'll certainly consider that. Any more questions of Dr. Lidzelter? I move that we approve the auction results. It seems that the auction was well run. There was a lot of participation. The market situation was stable. There was a lot of competition. And I think for the other reasons as stated by Dr. Lidzelter, I move that the auction results be approved. And I notice I didn't say anything about going into confidential session. Does anybody want to go into confidential session?
No, I'll second your motion, Mr. Chair.
Amy, do you want to go into executive session? Is there something important we should know? We know the names of the companies are there, some other facts. I mean, we've seen that in the past, so. Okay, that's all the discussion. All those in favor signify by saying aye.
Aye.
Any opposed? Any abstention? The motion carries. Dr. Lidzelter, thank you so much for your annual visit, or is it biannual?
Yes, it is by. Thank you.
Thank you, Amy. Right now, I would like to have Ms. Banks stand up, please. Tymone Banks. I want you all to say hello to our newest employee, administrative assistant. So welcome her aboard. Okay. Okay, number 3 is in the matter of the adoption of rules and procedures to implement the Renewable Energy Portfolio Standards Act. Will all the participating parties please come forward? This matter has been around since 2005, and we've been in litigation and other things, so we hopefully have Dave Stevenson going to be calling in at some point in time. I'm not sure when that's going to happen.
Mr. Chairman, we have to call Mr. Stevenson.
Yeah. The options were for us to have a hearing, or the staff was kind enough to bring some pugil sticks and boxing gloves. So if necessary, we'll use this space in the middle to get the exercise.
Hello.
Mr. Stevenson, welcome.
Yes, thank you very much.
You can hear okay?
Yes.
Okay. Okay, before we get started, I want to make a little bit of I want to make a comment or two. Number one, I really wasn't too involved. There's been, like I said, litigation, and I know there's been discussions between the parties. And I really wasn't part of that at all. But at some point in time, I got, I guess, a little frustrated with how things were going, and I decided to talk to some people about the negotiations. So I want people here in this room to know that I've talked to Mr. Slater, for example. I've talked to Mr. Barua, for example, Mr. Hardigan, for example. Is also, to be frank with you, I got a call from the Secretary of State after our last meeting. And he said to me, Dallas, he says, I'm not happy, but I understand why you did what you did, and it's okay, basically is what he said. He understands our role with respect to these matters. He respects that role, and I don't feel any type of adverse pressure, et cetera, because of our decision, nor do I think it taints in any way what we do here today. I've talked to other people. I've talked to Delmarva Power and Light. I've talked to the solar people. I've talked to Pam Knotts, just basically talking to them about the nuts and bolts of the solar rec program. That's before, and also, yes, I did have a very nice lunch. He didn't pay for it. We paid for each of our own lunches with the secretary, Sean Garvett. We had a great conversation. A lot of it was pretty candid about the RPS and, you know, some of the comments that you've seen in writing around the litigation table or heard in negotiations were made by him. And then naturally I explained, you know, why we made the decision we made the last time we were in the meeting. And I also explained to him that the last time we were sitting here at a meeting, I looked up and I didn't see anybody at that table over there. I didn't see anybody who bid in the auctions. I didn't see anybody who, like Delmarva Power and Light. I didn't see anybody at all, not even Denrec. So I thought it would have been pretty inappropriate to make a decision about the marketplace when we really had no information about the marketplace at our last meeting. We really, in my opinion, and this might differ from the opinion of my fellow commissioners, is we made a decision that this commission, once the litigation ended, we want it to proceed, we want the litigation ended, and I think that was the primary purpose of our vote. And hopefully we'll have a decision out of Superior Court in the immediate future. On the other hand, I had a concern about the marketplace. One of the reasons I had that concern is I don't know enough about the marketplace, like maybe as I should. And they weren't represented or they weren't here at all last time, and Delmarva Power wasn't here. So I didn't feel like we had all the parties in the room so we could have a nice, candid, and frank discussion about what our infighting may be doing to the marketplace. And we, thus as commissioners, don't really know what the practical consequences are to the consumers, and we're going to find out because Ms. Iori is going to tell us, and as well as Mr. Stevenson. Mr. Slater is going to tell us, or both of them, because I wouldn't rule Ms. Iori out of it. So anyway, I guess we're going to hear from, obviously, from Denrec today. And I saw at least one solar provider in the room. I'm not sure if they're intending to speak at all, but, you know, see. Okay, so the bottom line is that I just want everyone to know that I have been in discussions with people, and that the term ex parte is very familiar to me. And I consciously, when I was talking to the secretary, made it pretty clear to him that I would discuss the issues surrounding the litigation, but that I certainly haven't come to any opinion or conclusion with respect to the facts surrounding the marketplace, because I just don't know the issues and they haven't been argued before me. And I don't feel in any way constrained about what decision I make. I think that I'm going to make a decision based upon the merits, as I'm sure all the other commissioners are. After I've heard, you know, we've heard from everyone. Thanks to Mr. Myers and Mr. Stevenson for their input. I also, obviously, will be hearing from other people as well. Any other commissioners wish to make any comments, or anybody want to, any of the parties want to make any motions and/or make any comments? This is sort of an opening statement, I guess. Why don't we, I think that, why don't we do the courtesy of our ex-attorney here at the commission, let Mr. Myers go first and give a sort of a brief statement. Is this, we just want to go around the table, ladies and gentlemen? We'll just go in that direction, and we'll leave the staff and the public advocate for last, and then we'll have a little bit of rebuttal, and then the commissioners will talk about whatever the issues are on the table. I guess one issue is the request by the secretary that the rules and regulations be restarted, so to speak. Terminology, I'm sure different people will use different terminology, but I guess they're looking at a May 31st, 2020 date. That's obviously opposed by people in the room. So let's start off.
Mr. Chairman, I know you have a perspective, but as I look at some of the documents that I've seen, and by the way, I haven't spoken to anyone since our last decision-making here at the commission, But my clear perspective is that there is an internal, if you say infighting, wherein the tug of war seems to be between the Public Service Commission and DENREC. It would, I think, be of most value to me to first hear from DENREC in terms of what their proposal is in front of the commission, and then from there, bring the other parties to speak.
I think that's a highly appropriate observation, and usually we start with the applicant or the person asking or requesting some action from the commission. So I think, Commissioner Gray, thank you for that suggestion. Mr. Tweedy?
Thank you, Chairman and Commissioners. Jameson Tweedy, Special Assistant Deputy Attorney General with the Delaware Department of Justice on behalf of DENREC. With me today are Dana Cobb, the relatively new Director of DENREC's Division of Climate, Coastal, and Energy, and Tom Noyce, the Principal Planner for Utility Policy, also of DENREC's Climate, Coastal, and Energy Division. I believe this is the first time Director Cobb has had the opportunity to address the Commission, and will offer a few comments. And after Director Cobb's comments, I will be happy to address some points as well, and obviously answer any questions the Commission has.
Thank you, Chair Winslow and Commissioners, for the opportunity to speak with you today. It's a pleasure to meet you. When I arrived at DENREC a few months ago, I found that our two agencies, along with the public advocate, were engaged in a protracted dispute over the freeze provisions and other interpretations of the Renewable Energy Portfolio Standards Act, the roles of our respective agencies in that process, and effectively the future of renewable energy in Delaware. REPSA indicates our two agencies should consult on its freeze process. Instead, we find ourselves locked in litigation in the Delaware Superior Court, and it seems also pushed into another standoff in this docket by the Commission's assertion that DENREC should submit freeze calculations even as the Superior Court litigation proceeds. DENREC does not believe that this confrontation between our agencies is beneficial to the state. Nevertheless, DENREC sees no alternative as the Commission has promulgated regulations that, in DENREC's view, conflict with the plain language of the statute and with REPSA's fundamental purpose to create a market for renewable energy in Delaware and to reduce the cost to ratepayers by continuing to expand the use of new, cheaper renewable energy. As stated in Secretary Garvin's letter dated December 2nd, 2019, and separately in submissions to the Superior Court, the administration is seeking a legislative solution to these issues. In an effort to find a way to resolve our differences, Secretary Garvin, Secretary Bullock, and the administration have spoken at length, and DENREC also would welcome more communication and open lines between DENREC and the PSC. Secretary Garvin's letter to the Commission on Monday attempts to forthrightly lay out DENREC's position on the calculations. I will not go through the details of the letter, but I do want to highlight a key points that would be good for this docket. The purpose and success of REPSA in creating a market for renewable energy resources and reducing their cost over time, why DENREC did not submit calculation, the importance of the secretaries of DENREC and state working together, the administration's desire for legislative solution, and that we are all better served by staying this matter through the end of current compliance year. REPSA, as it states in the statute, was intended to establish and grow a market for renewable energy in Delaware. REPSA identifies the numerous benefits of renewable energy to Delaware and its citizens. These benefits include improved regional and local air quality, improved public health, increased electric supply diversity, increased protection against price volatility and supply disruption, improved transmission and distribution performance, and new economic development opportunities. REPSA has been successful to date. Solar capacity in Delaware has grown from 2.3 megawatts in 2008 to more than 112 megawatts today. Delaware is now home to more than 5,000 solar installations. According to the Solar Foundation, the solar energy industry employed 468 workers in Delaware in 2018. REC and SREC prices have come down as the market for renewable energy has grown, just as the law intended. REPSA is also a key mechanism to effectuate state policy to improve air quality and reduce greenhouse gas emissions. as renewable energy reduces demand for fossil fuel generation in the PJM regional grid. Thus, REPSA is successful both in its statutory purpose and in achieving the governor's commitment to climate. So why did DENREC not submit these calculations? First, Secretary Garvin in his letter sets forth DENREC's position that this matter is premature for deciding today, given the fact that administration has an ongoing focus for legislation that will resolve these disputes and strengthen REPSA, and the fact that Judge Wharton has not yet ruled on three motions pending before him. Also, Secretary Garvin repeated his request for a stay through the end of compliance year to give us time to reach a legislative solution. I hope you will agree that we should all be uncomfortable with where we are. State agencies at each other in court and against odds in this docket. In DENREC's view, we should take every opportunity we can to work to resolve these issues. DENREC is seeking to do exactly that, with Secretary Garvin, Secretary Bullock, and the administration actively engaged in seeking a solution. The ongoing confrontations, including this docket, however, make the task of crafting legislation all the more difficult. As noted in Secretary Garvin's letter, the administration desires a legislative solution to these disputes that will resolve the issues of this docket, resolve the current litigation in the Superior Court, and strengthen and extend REPSA moving forward. Given the drastic impact of a freeze, we should all want to step back to give the administration and the legislature the chance to resolve these issues. DENREC proposes a stay of this docket through the current compliance year, with the RPS percentages held at the statutory level, meaning the current RPS compliance year. This will allow the administration the opportunity to pursue a legislative solution to these disputes and to strengthen and extend REPSA to continue to benefit Delawareans into the future. If we all agree that these issues require a legislative fix, then we should agree that we should try to create an atmosphere that is conducive to such a fix. Both in this matter and the many others where our agencies intersect, Delawareans will benefit from greater communication and collaboration between our agencies. We all represent the public interest of Delaware, and we should work together accordingly. Again, thank you for the opportunity to address the commission. We believe that direct communication is best for resolving the issues before us today. I will now turn it back to Mr. Tweedy.
Thank you, Ms. Cobb.
Thank you, Dana. In addition to answering any questions the commission may have, I wanted to address the submissions of Mr. Stevenson and Mr. Myers, as well as one point that sort of underlies all of this. What Mr. Myers, Mr. Stevenson, and the public advocate have asserted, and what the commission's regulations would permit, is a long-term freeze of the RPS percentages. DENREC believes this, in conjunction with the direct conflicts with the statutory language of REPSA that we have detailed elsewhere, is strong evidence of the fact that the commission's regulations and the approaches advocated by Mr. Myers, Mr. Stevenson, and the public advocate are in conflict with the language chosen by and the intent of the General Assembly. The PSC's regulations, if implemented, could lead to a long-term freeze of the RPS due to the inclusion of Bloom Energy and the exclusion of transmission and distribution costs in the calculation the Commission has established under Sections 354I and J in its regulations. DENREC opposed this construction as the regulations were being developed, but it was nonetheless adopted. Bloom Energy costs continue to exceed solar and other eligible energy resources, and standing alone, when combined with the regulations' exclusion of transmission and distribution costs.
Excuse me, I'm sorry to cut off Mr. Tweedy. I understand why we're here today. What Mr. Tweedy is giving you is a re-argument of what is before the Superior Court to be argued, if it is argued at all. Bloom, their arguments that the regulations don't comply with REPSA, that they don't like, DENREC does not like the statute REPSA. I think we're here about submitting the calculations. The statute is a statute, it is on appeal, the regs are in effect, and the sole matter is submitting these calculations, it's not about arguing the same thing that is argued in the Superior Court. They're two different avenues, and they're distinct. And I don't know why we should entertain another Reg 56 argument here or entertain what is on the papers pending in Superior Court. It seems to go far off the track of why we're here. There's a sole issue for being here, and I don't think what Mr. Tweedy is presenting addresses that. It addresses underlying arguments, but not DENREC's having not submitted the calculations under regulations which are in effect and not stayed. That's the sole issue.
Well, thank you.
Chairman Winslow, I knew I said I was going to zip it, but this is a legal, sort of a legal question, and may I address that?
Absolutely.
Thank you. Well, I mean, the proper interpretation or not of the statute as set forth in your regulations is before the Superior Court, and this commission now has been divested of jurisdiction on that. So that question is not before you today, and it wouldn't be before you until the court rules. The court could send it back to you, in which case it would be before you. But right now, that's not the question before you, and you don't, I mean, I don't like to tell the commission they don't have jurisdiction over something, but you don't have jurisdiction over the merits of whether or not the regulations properly interpret sections 354I and J anymore. So to the extent that DENREC is making those arguments, they are irrelevant to the question that is before you today.
Chairman, could I respond?
Yes, please.
So the issues that are before the court are DENREC's appeal of the regulations. DENREC believes that the regulations do not comply with the statute, and DENREC has lawfully challenged those regulations. DENREC has further asked the court to stay implementation of the regulations. If Ms. Iori thinks that any jurisdiction of this body is divested, DENREC would refer you to the fact that we have asked the court to stay these regulations, and indeed the commission already has granted one extension of deadlines. To Mr. Walsh's point, all of these points that I'm making, if I'm allowed to continue, go to the fundamental question that is before you today, which is why did DENREC do what it did in terms of not submitting the calculations on the date requested by the commission? All of these are tied together, and I would certainly appreciate the opportunity to be allowed to speak. I'm not sure I've encountered the occasion where I was cut off mid-statement.
It's happened to me, so you'll get used to it over time. I would say something to Ms. Cobb, and I do appreciate your comments, and I wish you well in your new position. And I do think that your general comments when you first started were very appropriate, and I intend to give you all great latitude with respect to the argument. I've got plenty of time. I've got all afternoon. I understand, and I was there for the argument, so I understand what you're arguing about in court. So, and I think that we're going to let Mr. Tweedy proceed as he planned.
Thank you, Chairman. As I was saying, Bloom energy costs continue to exceed solar and other eligible energy. Yes, I am sorry. Bloom energy.
I told you you get interrupted again.
I didn't know it was quite so soon, but fair enough. I get critiqued to slow down, not infrequently. Bloom energy costs continue to exceed solar and other eligible energy resources, and standing alone, when combined with the exclusion of distribution and transmission costs from the calculation under the Commission's regulations, would allow the potential to freeze the RPS percentage well into the future. Bloom's contract has more than a decade remaining. Senator McDowell, the prime sponsor of the 2010 REPSA amendments, which have been cited by others in support of the idea that a freeze must happen, in fact, said on the Senate floor that he thought a freeze would be a temporary matter and described the cost cap provision as a one-year, quote, circuit breaker, end quote, that would, quote, suspend the program for that year, end quote. That concept of a one-year circuit breaker or suspension was repeated later in Senator McDowell's testimony. And this concept of a limited circuit breaker is consistent with the statutory language. A long-term freeze of the RPS percentage is not. DENREC has detailed the numerous reasons for this in its other submissions. However, I would like to quickly hit two. First, Bloom Energy should not be included in the calculations because based on the plain language of the statute, it is neither an eligible energy resource, as that is defined in section 352, nor solar photovoltaic, as also defined in 352. And it is therefore outside of what is addressed by the relevant provisions of sections 354I and J. Second, a long-term freeze is wholly inconsistent with REPSA's purpose. REPSA's intent is to establish a market for renewable energy in Delaware and to lower the cost from renewable energy to consumers by continuing to grow the renewable energy market. That's stated in section 351C. REPSA explicitly contemplates, as Dana Cobb mentioned, that there are numerous benefits from renewables that flow to Delawareans. Those include improved regional and local air quality and the other items stated by Ms. Cobb, which include both environmental health and utility benefits. REPSA is not, as advocated by others on this docket, concerned exclusively with costs. Indeed, REPSA explicitly contemplates that the benefits noted are sufficiently important to, quote, that electric suppliers and consumers share an obligation to develop, end quote, renewables. That's 351B. The General Assembly's intent that renewables should continue to increase is emphasized in multiple locations throughout REPSA. For example, section 354C emphasizes, quote, the goal of 25% from eligible energy resources, end quote. A long-term freeze would prevent achieving that goal within the scheduled timeline established in Schedule 1 of Section 354 of REPSA. Section 354D emphasizes the same thing, stating, quote, the scheduled percentage increases toward meeting the goal of 25%, end quote. Section 354D indicates that levels cannot be lowered, and Section 354B provides that this commission should establish RPS percentages, quote, for compliance year 2026 and each subsequent year. In no case shall the minimum percentages established by the commission rules be lower than those required for compliance year 2025 in Schedule 1, end quote. If a long-term freeze were implemented, it would be impossible for the scheduled RPS percentages to meet and then move up from the schedule established by Schedule 1 and would directly conflict with both the language of REPSA and the clear intent of the General Assembly. Turning to Mr. Stevenson's submissions, which I will attempt to be as brief as I can. I'm sure the Commission anticipates that DENREC disputes numerous aspects of Mr. Stevenson's submissions. I do feel compelled to address a couple points. Mr. Stevenson asserts, quote, DENREC has continuously manipulated the administrative process to delay a freeze, end quote. That's from his November 26th submission. This both misrepresents the statute and the facts. First, it is not possible for DENREC to, quote, continuously manipulate the administrative process to delay a freeze, end quote. Rather, REPSA provides DENREC the explicit authority to determine whether a freeze should or should not occur. REPSA, by its plain statutory language, gives DENREC the authority and the discretion to determine whether a freeze should or should not be implemented. REPSA provides thresholds which permit but do not require DENREC to implement a freeze if it determines that a freeze would be appropriate based on the circumstances and consistent with REPSA's statutorily mandated purpose. Second, it is the Public Service Commission that has established the timelines and procedures for all aspects of this docket. As everyone is aware, this docket has lasted years, long predating my residence in the Department of Justice. DENREC has respected the PSC's deadlines in all aspects of this docket up until this calculation. As to this particular deadline set by the Commission, DENREC does not believe it is appropriate to submit these calculations, both given the pending litigation and given the administration's desire for a legislative solution. DENREC has availed itself of the legal right to challenge the PSC's regulations because of its view that they conflict with the statute, and DENREC has asked the Superior Court to stay implementation of those regulations. All of these actions are lawful and procedurally appropriate. The parties had agreed to a stay of the deadline once already, so as to allow Judge Wharton to rule on the outstanding motions in the Superior Court case, including DENREC's motion to stay the regulations and the Commission's and the Public Advocate's motions that DENREC's complaint should be dismissed. Judge Wharton still has not ruled on those motions. Thus, the reasons which gave basis for the first extension of that deadline continue to exist. DENREC has detailed its position in the December 2nd letter that Dana Cobb noted, and DENREC respectfully requests that the Commission extend its deadline further, as stated, to May 31st, 2020. Mr. Stevenson further asserts that DENREC's, quote, continued obstruction by failure to provide the cost cap calculations for the PSC's consideration is a blatant attempt to defeat the legislative intent. Mr. Stevenson further goes on that, quote, it is likely the cost cap was exceeded as early as 2012 based on the cost cap legislation passed in 2010, end quote. These are from his November 26th submission. First, I would just note that Mr. Stevenson is not, to my knowledge, a lawyer, and yet he appears to be advising the Commission on how it should interpret REPSA. Mr. Stevenson participates in this matter as an officer of the Cesar Rodney Institute, and appearances before the Commission are governed by Commission Rule 2.1, which provides that a representation by an attorney, officer, or other qualified agent is subject to the rules of the Supreme Court of Delaware. The Delaware Supreme Court has advised that, quote, in general, one is deemed to be practicing law whenever he furnishes to another advice or services under circumstances which imply the possession and use of legal knowledge and skill, end quote. That's Delaware State Bar Association versus Alexander, 386 8th Atlantic 2nd at page 661. I would just ask, at what point Mr. Stevenson's representation of policy interests of the Cesar Rodney Institute, which he's entirely appropriate and entitled to provide, blur it into legal advocacy. And I think advising the Commission on the interpretation of a statute and the General Assembly's legislative intent gets uncomfortably close to that line. I would urge both Mr. Stevenson and the Commission to be mindful of those requirements. As to Mr. Stevenson's assertion that DENREC is somehow defeating the legislative intent behind REPSA, that is simply divorced from the statute. REPSA provides DENREC with the discretion to freeze or not freeze. The legislature specifically delegated this authority to DENREC, and the statute nowhere provides the Commission the right to overrule DENREC's discretion. The express legislative intent is embodied in REPSA to establish a market for renewables and to increase the percentage of electricity from renewables. As Director Cobb noted, REPSA has been successful in achieving its goals. REC and SREC prices have trended down, and DENREC is well within its discretion to determine whether or not a freeze should be implemented. Indeed, REPSA's provisions in 354I and J are clear that the thresholds act as a floor, not a ceiling. DENREC has no authority to implement a freeze if the percentage thresholds are not met. DENREC has the discretion to implement a freeze, but also the discretion not to implement a freeze above those percentage thresholds. Finally, I think the stridency with which Mr. Stevenson and others attack DENREC in this matter is somewhat remarkable, given that REPSA provides numerous other provisions which could allow the RPS percentages to be slowed or accelerated. Indeed, the Commission itself has at least 2 statutory bases by which it could accelerate or slow the RPS percentage, and it has not availed itself of those either. For example, Section 354C provides that, quote, beginning in compliance year 2010 and in each compliance year thereafter, the Commission may review the status of Schedule 1 and report to the legislature on the pace on the statute of the pace of the scheduled percentage increases toward the goal of 25% from eligible energy resources. If the commission concludes at this time that the schedule either needs to be accelerated or decelerated, it may also make recommendations to the General Assembly for legislative changes to the RPS, end quote. It is noteworthy that this provision provides discretion to the commission. It uses the word may, the commission may. May clearly signifies that it has the discretion to do so or not to do so. To my knowledge, the commission has never availed itself to recommend to the legislature that the RPS percentage should be accelerated or slowed. And to my knowledge, Mr. Myers, Mr. Stevenson, nor the public advocate have ever challenged that. Similarly, Section 354D provides that, quote, beginning in compliance year 2014 and in each compliance year thereafter, the commission may, in the event of circumstances specified in this subsection, and after conducting hearings, accelerate or slow the scheduled percentage increases toward meeting the goal of 25%, end quote. The section provides detailed parameters for when the RPS percentage may be accelerated or slowed. And again, it's noteworthy that this provision also uses the term may. It provides discretion to the commission to choose whether or not to avail itself of this position. Again, to my knowledge, the commission has never availed itself of this option and so has exercised its discretion not to. Again, to my knowledge, neither Mr. Stevenson, Mr. Myers, nor the public advocate have ever challenged that. Instead, they have reserved their attacks for DENREC. Particularly when viewed in this context, the statutory discretion granted to DENREC in sections 354I and J is very apparent. When the legislature wanted to grant the commission power, it did so explicitly. In contrast, in 354I and J, it gave the primary authority to DENREC. Again, the General Assembly crucially chose the term may for each of these three sections I've just discussed, as opposed to the mandatory term shall, which it used in other areas of REPSA. If I could turn briefly to Mr. Myers' submissions. First and foremost, Mr. Myers' submissions are based on a complete hypothetical that the commission had in its regulations adopted the version of the calculation that DENREC had sought. The commission did not. Thus, what Mr. Myers is supposing is completely divorced from the facts we find ourselves in. Nor could the commission adopt the calculation that DENREC had suggested without further rulemaking. So again, this is completely divorced to where we find ourselves. Mr. Myers' submissions, again, ignore the discretion that I just discussed in DENREC's authority to freeze or not to freeze under sections 354I and J, the distinction between shall and may. Mr. Myers also ignores that nothing within 354I or J or elsewhere in REPSA permits the commission to overrule DENREC's discretion on this issue. If that is what the commission's regulations purport to allow, and that is what Mr. Myers, Mr. Stevenson, and the public advocate seem to all be relying on, that the commission will unilaterally grant itself the power to overrule DENREC's decision. This is not consistent with the statute. Finally, there has been some discussion in Mr. Myers' submissions and the prior submissions in the Superior Court regarding either the 2018 or 2019 compliance year levels. I will not address that unless the commission would like me to. In DENREC's view, it is abundantly clear that we are in compliance year 2019. That started on June 1st of 2019, and that to the extent any freeze was contemplated, it would be to this year's levels. As Director Cobb stated, there does not seem to be any value to either of our agencies or the state in this confrontation. DENREC has permissibly challenged the PSC's regulations in Superior Court and has further moved that the implementation of the regulations be stayed during that court proceeding. The court has not yet ruled, and the parties had previously agreed that extending this deadline to allow the court to rule made sense to all parties. Despite the court still having not yet ruled, which we hope Judge Wharton will soon, the commission has not further extended the deadline. All parties would be well served to await the court's ruling and to determine their next steps, as the court's ruling may render moot or otherwise at odds any actions that are taken. Similarly, there's no value in insisting that this process continue despite the administration's desire for a legislative solution and the active steps of both Secretaries Garvin and Bullock to effectuate such a solution. Both agencies will benefit from a legislative solution that resolves these disputes, and Delaware will benefit from a strengthened REPSA. The Commission, of course, has the authority to extend the deadline in its own regulations, as it has already done so once. DENREC urges the Commission to do so again to allow the agency's breathing room to effectuate an administration-supported legislative solution by extending the deadline until the end of the current compliance year, May 31st, 2020. I'm happy to answer any questions the Commission may have. Thank you.
Thank you very much, Mr. Tweedy. Ms. Cobb, we're, this view's been going on between the Public Service Commission, I guess the DPA, and DENREC for a while. And us 5 commissioners, we show up on certain afternoons twice a month. We're not involved in any of the little stuff, the elbows are being thrown back and forth. All we do is get here, we listen, and we make the best judgment we can based upon what you all are telling us. So, and we're also, we're part of the legislature, so to speak. We really look to what the legislature says and what the statute says, and we try our best. And of course, DENREC doesn't agree with us. We tried to give the whole ball of wax to DENREC, and Ms. Iori wouldn't let us do it, and we got reversed. So, I mean.
Not that I wouldn't let you do it.
Judge LeGros wouldn't let you do it.
That's true, that's true. So I do think that Mr. Walsh has a point with respect to certain parts of your argument, because we're not certainly going to take Bloom out of the calculation at this point in time this afternoon. But I would like to hear what you have to say about, I think it was Mr. Myers' comments about the regulation and the statute and how much power the Public Service Commission may or may not have with respect to extending the time for us to wait for the decision, or extending the time to 5/31, or doing something other than what's already written in our regulation.
So my simple answer to that is that the Commission certainly has that power, and I'm sure your attorneys can advise you on that. In fact, your attorneys already presented to you one extension of that deadline. It was originally scheduled for October 14th, 2019, and was subsequently extended out to November 13th, 2019. So that deadline has already been extended. There's clearly authority to do so, and there is clearly authority for the Commission to extend it further.
But is there a point in time at which the Commission, it really isn't just extending a deadline, but they're issuing a stay, and we'd have run into legal difficulties, as Mr. Myers, I think, suggests?
I do not share that view. The status quo is the scheduled percentage increases in Schedule 1 of Section 354 of REPSA. That is how everyone is anticipating that it will operate absent some freeze of the percentage. A freeze can only occur through certain actions, and none of those actions have happened. So as long as nothing has happened, everyone operates as if the statute guides as it should. Now, there may be some practical realities to when auctions need to happen and the like, but again, all of those would happen as they otherwise would, according to the statute, under DENREC's proposal.
Okay, so you're getting a little closer to what I'm interested in. What effect, I mean, if we went on the same course we have right now, we're waiting for a decision in Superior Court, and we have the participants in the marketplace who I assume at some point in time have got to expend time, energy, and manpower, I guess, to run an auction. We saw one, results of an auction here today went very smoothly, and I think that this commission would like to see the next time we have an auction for the SRECs that run very smoothly as well. So I'm trying to figure out, what we're doing, what sort of a practical effect is it having on the people out there that we're here to serve?
I
I
think
mean, I
that-
hear all your legal arguments, but tell me, how is Dale's company being affected? How are the consumers that Mr. Slater represents, how are they being affected by our actions?
So I think it's a great question, and I think Your Honor is right to look at Dale and others who will be affected personally by that. So I would welcome their input.
Okay.
Oh, certainly, thank you.
Well, let's, one second. Dale, we'll hear from you, but is that Mr. DiNardo?
Yes, sir.
I don't think I've ever had a chance, I don't think we've met before.
No, sir. I am the Energy Fellow for Senator McDowell. I've been working with him since January of last year. Probably going to continue till the end of this month, not sure. I'm actually a bridge engineer. I just graduated from UD, so my days are limited here. But I have done heavy research. I concentrated on solar in my master's degree research. So
Can I-
go
I'm
ahead.
sorry for interrupting you, but we need a bridge here right now. Can you build it?
Of course I could.
What is your,
Bridge of communication between the PSC and DENREC. We could do that.
Mr. DiNardo, what is your first name? Is Christopher?
Nicholas.
Nicholas.
Yep. So I'm actually here today on behalf of Senator McDowell. He was unable to make it today as he's speaking at a conference. So I've been instructed to indicate for the record that the senator does not regard a commission meeting on the topic as helpful at this point in time. Obviously, the state is pursuing litigation in the court, and further, the legislature, as Mr. Tweed indicated, that there may have been some incorrect interpretation of the legislative intent of the freeze. So, therefore, the legislature and the courts are the proper vehicles to address this matter. That's what Senator McDowell would like for me to say. But listening in, as a citizen of the state with limited time here, I would also like to make some comments.
Chairman
Is that all right?
Chairman Winslow, this is so procedurally improper, I cannot begin to tell you how much procedurally improper it is. As much as I'm sure we're interested in what Mr. DiNardo has to say, he did not submit any comments during the regulatory process. Neither did the senator.
Well, this whole thing is a little unusual, isn't it?
That doesn't mean you have to make it even more unusual.
Is there a moment for public comment? Because I'll wait as a part of the public.
I was just going to point out, Ms. Iori already knows this, and I was going to say to Mr. Tweedy that, you know, we understand that Mr. Stevenson is not a lawyer. Previously, I think maybe Mr. Myers had represented him, but we understand he's not a lawyer. And we don't make him wait till public comments generally to make a comment on something that he wants to make a public comment on. So I don't know, we sort of are pretty inclusive with respect to our comments. Mr. Slater, you have something else you want to?
And if I could just be clear, I have no objection to that aspect of Mr. Stevenson's participation. It's just the content and when it gets to the point of making legal guidance.
Okay.
Well,
Mr.
with all due
DiNardo,
respect,
Mr.
we have a lot of people here who aren't lawyers making legal judgments, so.
That's correct.
Take that with a grain of salt.
And we have people with legal degrees that maybe don't make the right decision all the time, too. So that's also truthful.
That is also true, too.
Yeah. So, Mr. DiNardo, I would love to hear from you. If you want to wait, I guess if they want you to wait till public comment,
I'll wait. I think that's more
Okay.
appropriate.
And then, of course, that'll be after our vote, but that'd be good. But you don't want us to do, you don't want us to do anything
All right,
anyway, so.
well,
Right? I mean, the senator doesn't want us to do anything, apparently.
well, his recommendation is that the legislature and the courts handle this.
Okay, I would think that DENREC is probably going to be appreciative of us listening to them and making a decision so we can move forward. Okay, thank you, Mr. DiNardo, and best wishes to you, by the way. I'm a big Blue Hen fan, so congratulations on
Thank you.
your graduation and best wishes in the future. Okay, we have, why don't we go to Mr. Myers? He's a lawyer. He's not dressed well.
Oh, I'm not a lawyer anymore.
Oh, are you retired from the bar?
No, I'm retired.
You are retired?
Yeah.
Well, congratulations.
Didn't want to pay the $100 a year.
Or have to pay for his own CLE.
Yeah.
pull the mic closer, please, Gary?
I'll try to be brief. Try is the operative word there. And I'll start out with two apologies, ask two questions, and then offer a proposal. First, apologies about my sweatpants and sweatshirt. A doctor 2 days ago told me to wear loose clothing and don't wear a suit. So this is, for the next 2 weeks, this is my formal and casual wear. The second is, I hate to deluge you with more paper in this procedure, but it's an important case, I think, and it's an important juncture in this case. And for me, the real problem is it's a real head scratcher. Because I'm not sure what we're doing here and what the commission is being asked to do and whether the commission's being asked to do it in the dark. And that goes to what's not been presented. The statute, the two subsections that Mr. Tweedy cites say, and I think command DENREC, the division, the director, or whatever it was, to make a determination, to determine if the total cost of compliance exceeded the percentage of a certain, the percentage of the total retail cost of electricity for electric suppliers. That seems to me to impose an obligation on DENREC to do something, to make a determination each year. It's not in the regulations, that's in the statute, and that's the obligation. What's really happening here to me, it seems to me, is DENREC doesn't want to live up to that obligation. They want to postpone it for a year. I don't think either they or you, respectfully, have the power to say that they can in effect forego their regulation. What makes it a real head scratcher about this, and it's alluded to in my first diatribe on the 27th, I think it was, is if you take DENREC's interpretation of total cost of compliance to exclude all the bloom costs, if you take DENREC's interpretation to include both supply, transmission, and distribution for its DP&L's revenue base, if you take those numbers, which DENREC's not told you, but if you take those numbers and apply their interpretation, the way I discern it from what public information that is available is, you're still over the cap. You're still over the percentages. There has to be a freeze process. Whether you agree with now with DENREC, whether it's discretionary or mandatory, there has to be some discussion about a freeze. What they want to do is, in effect, not tell you the numbers. They want to tell you the numbers under their own regulation, and Mr. Tweedy now says, if you do it under their interpretations, just to see what it is, that's irrelevant. But how can it be irrelevant? If you remember 8 months ago, I'm into analogies. If you go in to the University of Delaware and the professor gives you a test and says, you have to get 20 right to pass this test. You take the test and you get it back, and lo and behold, he says you got 10 right. You flunked. But you go to him and say, that's not right. You missed something. You missed 5, and you got 5 wrong. Professor, you got 5 wrong. My answers are right in 5. And he says, okay, you're right. You get a 15. Under DENREC's view, you pass. Well, that can't be right. You're under 20. And that's what's happening here. Under their own interpretations, if you apply it to the numbers we know, you're still over the percentage caps. So there's a triggering event that happens no matter whether you go with the PSC's rules or with DENREC's interpretation. There's got to be some discussion of a freeze. And DENREC is trying to avoid that by not giving you any numbers. So that's what makes my head scratch about this whole thing. DP&L can solve this problem by giving you the numbers under DENREC's interpretation, and you can go forward with more information. So that's my proposal in a way. My proposal is that you direct DP&L to give you and to make publicly available for all of us and everybody else the numbers they reported to DENREC under your rules. The total cost of compliance, the which includes the rec purchases, the SREC purchases, the green fund requirement, well, I'm sorry, no, and the Bloom Energy, which will have information that you don't even have now. You should also direct DENREC to give you their portion of the total cost of compliance, which is how much of the green energy fund was expended during the last compliance year. That's included in the total cost of compliance by statute. You also, DP&L, when they give you the information they're required by your rules to do, give to DENREC, make it available to you, you'll know under your rules what the total retail cost of electricity is. So you can run your rules with real numbers and find out what the percentages are. But I suggest you go one step further, and that is you ask DP&L to in effect give you the retail cost of electricity as DENREC's older rules applied. And then you can figure out, your staff can figure out whether, even if you applied DENREC's definitions, their interpretations, whether in effect they're over the percentage limits that are set forth in the statute. And as I said, from the public information that I gained from DP&L's RPS report, I think they are. And I think they're significantly over. I think the overall is around 4%. And the solar is 1.4, 1.5. And I think that's conservative. So they would be over regardless. If they won the court case, they're still over. So why they want to postpone when even though it's just a flat out, we can't live by this statute. That's been the problem with this case proceeding from day one. The percentage limits set in 2010 didn't play out the way people thought them, and you can't live with them. DENREC can't live with them. The suppliers can't live with them. They've been over those limits since, well, they admitted in 2015 they were over, and I think they've been over every year since. So my proposal is, and it's set in the thing I sent you yesterday afternoon, I don't know if you got it in time or not, is to do those three things. Tell DP&L to give you the numbers that they reported to DENREC. Tell DENREC to give you the numbers that they're required to report about the Green Energy Fund. And then tell DP&L, if they would, work up what the retail cost of electricity for suppliers under DENREC's former definition would be. Then your staff can run them through, find out what the percentages are under your rules, find out what the percentages are under DENREC's interpretation, and come back before you next week and say, these are the real numbers. We're not talking about principles and purpose and all that. These are the real numbers. And if the real numbers all the way around, either on this side or on that side, are over, then you have a much better case of deciding whether, in effect, you have the authority just to say, well, they're over under anybody's interpretation, but we're just going to postpone it so the legislature can fix it. I don't think you have that power. There's a lot of laws out there that people would like to postpone until the legislature fixes it, but you can't suspend currently enacted laws, and that's what they're asking you to do. So there's my pitch.
Mr. Tweedy, I like the everything he said. The last sentence has the most importance to me. How about addressing that?
To address that, we are not suggesting that the law, the statute should be suspended. The exact opposite. We think the statute should control, REPSA should control. It is the regulations and the Commission's insistence that this calculation be provided on this date, which is nowhere in the statute. That is solely in the Commission's regulations, be suspended. And there is perfectly adequate authority to do that.
Mr. Myers?
I would be happy to
Mr.
respond on other points as well.
Yes, sir. Mr. Myers?
Mr. Noyes is here, yeah. He and I have been at it for a long time. What's ironic about that situation is, what the complaint is and what the Secretary Garvin's is you're making your freeze determinations too late. You're making them in the next compliance year. You should have made them earlier. I mean, that's the argument here. So what's the harm of pushing it back even further? The timing process was lifted from DENREC's original regulations. They're the ones who proposed the exact timing process that you have. So what goes around comes around, I guess. But the statute says DENREC determines something every compliance year. Did they determine anything for 2018-19? Well, if they did, they don't want it out there in the public. Are they going to determine anything for 2018-19? I don't know. They're hoping the legislature can fix it. But you just can't say we don't like the result that's going to be generated, so we just ignore the law.
Assuming that this commission has the right to, in some wordage, put off the compliance of DENREC until May 31st of 2020, what effect would that have on the marketplace? Do you know? You may not know, Gary, Mr. Myers.
I have no clue. I know what effect it had on my wallet.
What effect, that's important, what effect would it have on your wallet?
Well, it's going to knock out a percentage of what's the reasonable compliance charge.
Okay, so
The problem is the renewable compliance charge. And that's what Senator McDowell and Secretary O'Mara said this law was all about. It was in effect to ensure ratepayers that they wouldn't see any impact from the 2010 legislation. That's what this is DENREC's law that we're arguing about. They're the ones, through a secretary, who proposed it with Senator McDowell. So from a consumer perspective, the problem is these promises were made in 2010 as consideration for raising the yearly quota amounts. People back then, the legislators, Joe Booth and all them, said, how do we know this isn't going to have runaway cost? And both Senator McDowell and Secretary O'Mara said, don't worry about it. We got something brand new in here. A consumer protection to protect ratepayers from the impact of this law, and that's the cost caps. They're going to be the circuit breakers. If it goes over, click. So it may be harsh, it may be difficult, but that's exactly the purpose of the cost cap provisions. And that's how they were offered.
Mr. Slater? You probably don't have anything to say?
Mr. Chairman and Commissioners, with all due respect, I will allow Mr. Davis to go first. I think you wanted to hear from all of them before you heard from us, or,
Okay.
I mean,
Yes, sir. Mr. Davis, will you address the main question I want to hear today, which is, I mean, we've heard all the legal arguments, Ms. Cobb, many times. Go ahead, sir.
Yeah, thank you, Chair and Commissioners. Sure, I am Dale Davis. I am the president of the Delaware Solar Energy Coalition and also operate a solar energy installer in Delaware since 2010. Actually, I'm sorry, since the year 2000. Yep. The impact of today's decision and the impact of a freeze will be substantial in Delaware. We have approximately 450 people currently employed in the solar industry in Delaware. That employment would be immediately impacted. The REPSA is what enables us to actually continue with solar. Since that law was originally passed in 2010, it's been attempted to be repealed legislatively twice and failed to be repealed that way. And once those appeals failed, there has been a constant attack on the parsing of the language. I think many of the people in this room have sat through 5, 6 years ago, hours of testimony of does may mean shall or vice versa. And this is a continuation of that same issue. The legislation certainly has some issues in wording that may not be perfectly clear and has allowed this problem to occur. That has already chilled solar adoption in Delaware. The uncertainty created in the marketplace because of this has caused, especially on the adoption of larger systems, has caused those developers and those investors in those systems to hold off on working in Delaware because they don't know what the future in Delaware is going to bring. Those larger systems tend to be the absolute lowest cost way to get solar, resulting in the lowest cost SRECs, the lowest cost impacts to ratepayers, and we're kind of missing out on that already. I would implore that we very carefully consider making a freeze, and especially making a freeze under the current regulations, which looks like it would be in place for 12 years. I was sitting in the legislature in that little room in the back of the Senate during the vote for this when there was lots of stuff going back and forth with Secretary O'Mara and the senator about this cost cap. We were sitting there calculating how the cost cap would run, and under what was then the way that it was supposed to be done with the year-over-year increase and what the retail rate was defined as back then, we weren't going to ever reach the cost cap. And so we were not concerned. And we've seen great effects on the current, how it's been implemented over the years. At each auction that we have for SRECs, the SREC prices go down. We have the lowest SREC prices of any state with a viable RPS and SREC market in across the country. We're down to the low 20s on our average SREC price now versus other states nearby that are much higher than that. It's been a very effective program, and if we freeze it, we're not only going to stop that decline in price and those advantages to both the ratepayers and those who want to have solar in Delaware, but we're going to go back the other way. I mean, we'll lose jobs, we'll lose the ability to build solar when a freeze is lifted. The market's going to look different. There's going to be constraint on the providers in the market, and prices are going to go back up. I don't think this is not a way to look at the impact of costs long term. Maybe in the short term, a freeze looks good, but if you look out 5, 10 years, we need more solar in Delaware. We shift an awful lot of our dollars in Delaware go to buy energy that does not get produced in this state. We're talking in the neighborhood between all the utilities in Delaware, close to $1 billion a year that leaves Delaware's economy. It's a crazy amount of money when you think about that. Installing solar and renewable energy that generates in this state keeps that money circulating in this economy. It pays the people who work here. They go out, they buy things with that. The people who are saving money because they have solar have more money to spend locally. We have to consider some of those impacts of our decision-making process, and that's all I ask. I think that it's totally reasonable to wait until the court case plays out and to give the legislature time to correct all the confusion in the language before we decide we just need to implement a freeze and take the impact of that. Thank you.
Thank you, Mr. Davis. Mr. DiNardo?
May I piggyback on some of his comments? The solar industry is thriving in this country mainly because of the RPS, but if you look at what it's done to the market, it is on an exponential dive down on its cost, and it's predicted to keep going that way into the future. And many, like with the technology improving, its upside is tremendous. The most cost-efficient panel is only at 20% of efficiency, meaning there's 80% more energy there to harness. So I think for the future, solar is going to be the main source of power. It's right on the consumption, source of consumption. So I just want to say that, in terms of developing our state, it can be tremendous for the people of the state. But, I think I'm out of procedure here, so I should probably quiet up. Thank you.
Thank you, sir. Mr. Myers?
Can I say something in response to this now, or do you want to hear from Mr. Slater?
We're going to hear from, before we hear from Mr. Slater, I want to hear from Mr. Moore. Mr. Moore, please come forward and take Mr. Davis' seat if you don't mind. I want to make sure that you have all the people you're going to address at the same time.
I would just note for the record that none of these people who are testifying and giving you facts have been sworn.
Okay, we're going to make sure that I appreciate that.
Delmarva also filed no comments in Reg 56.
We want,
They have 1 foot planted solely in the middle.
well, I want to ask a few questions, Ms. Ivory. I guess we're going to swear the witness.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Full name, Mr. Moore.
Glenn Allen Moore.
Mr. Moore, what's your position with Delmarva Power?
I'm the Vice
Plant?
President of Delmarva Power.
And do you have any authority or any supervision or any work with respect to this issue?
Yeah, I am the responsible person for Solar Rex for Delmarva, Delaware, and sit on the task force as well as a voting member since the beginning.
Okay, and how long has that been about?
I want to say 9 years. I was going to say 8 years, but time goes.
Now, there's a marketplace out there. We've been doing all this legal talk here, but there's a marketplace out there, right?
Correct. I think the task force has spent a significant amount of time to make sure there is stability in the marketplace. And we have seen that stability. We come before you each year and ask for permission to run an auction. We come before you each year and we give you the results of that auction. That process includes staff and the advocate, and we either get a unanimous vote. There's some that abstain due to the fact that it comes before the commission. But that process, as I've testified before previously, has created a very stable marketplace, and the price of SREX, as identified for long-term contracts, has come down and is significantly below some of the surrounding states from a Delaware perspective.
When is the next auction?
So the process today is the committee has voted to the auction that would take place somewhere in the March, April, May timeframe next year. We are working on final submission. We're waiting on one sentence for that, and we should be filing that here in the next week or two to have an auction in next May.
And how many people were in the auction? How many participants are there ordinarily?
How many participants that apply to send in SREX? I don't know the exact number. The residential gets hundreds and hundreds of folks that apply, and then as the tiers go up to bigger and bigger, you might get 8 or 10 or 2 or 3, depending on into the very largest tiers that we have.
What impact would a freeze have on those hundreds and hundreds of residential customers?
There is no other place that I know of, especially in Delaware, that has the opportunity to have long-term contracts established. I will comment on one other area is the freeze issue. Again, not an attorney, not making a recommendation, but we are 6 or 7 months into the compliance year. Delmarva Power has the responsibility and takes it very seriously to meet the requirements of those requirements, and we have to look at a longer-term look at making sure that by May 30th, 31st of next year, we have to make sure that we retire the right amount of SREX. That process has gone on 7 months. Obviously, there's no calculation or freeze. It puts Delmarva and Delmarva customers somewhat at risk that if we were to reactively go back, we have to really consider when we buy RECs during the year, when we run the auctions, and those type of things. So there is issue and concern about, if this happened May 30th, not that we would wait that long, we would have already purchased all the RECs required. So from a Delmarva standpoint, the quicker we make the determination one way or the other is important to us, because as of now, we believe we have the responsibility to meet the 2019, technically it's called the 2019-2020 year, which is June 1st through May 31st. So that timing is getting critical from a company's perspective.
If this commission denied the request of DENREC with respect to a delay of the effective date to 5/31/20, what effect would that have on the marketplace?
Well, I'm not an expert in the marketplace, but doing the auctions, we have heard for years, as everybody, some of the folks around this room who have been involved as long as I have in a process, stability was one of the number one concerns in the legislation, and stability has been one of the number one concerns in how we create the auction process. So lack of stability I would assume, have some significant consternation to the solar industry and the ability going forward for us to get the cheapest RECs. But that's just from my observations of being involved in this for 8 or 9 years and watching how the process has moved forward.
How many vendors are involved in the marketplace? Do you know?
I do not know. We get submissions from literally hundreds of folks. Some use the vendor that put the solar on their roof, and some people, the statute allows them to put their own bids in. So, you know, if I had solar on my roof, I could put it in on behalf of myself. And literally we get close to 1,000, 700, 800 each year that put their RECs into the process to see if they can win a contract.
Now, obviously, the RECs cost money and the consumers get charged, correct?
That is correct.
How much does, for example, if this next auction went through, and we had an auction in the spring of this coming year, how much, under the current status quo situation, is the average, consumer consuming 800 kilowatts, or I think that's the figure you usually use? How much does that cost on a monthly basis?
So what happens is, if you assume that we put a maximum of 20,000 RECs into the auction for a long-term contract, those RECs have averaged, mid-20s, low to mid-$20. So $25 times, 20,000 RECs. So I can do the math, but I'll let somebody else do it with a calculator hand. Drew, I went to a public high school, so I probably will get the answer right, But the monthly fee is...
We have very good public high schools.
Yes, we do. So it's 20,000 RECs times, and if you use $25, which would be on the high side, Drew, what number did you get?
It's $500,000.
$500,000.
And how many consumers is that divided amongst?
Delaware has...
You can't include 12.5%, because that 12.5% are industrial loads, so you can't include 12.5%.
I don't know the exact customer count. A couple 100,000 residential customers and others, is that about right? 250,000? So I've heard from...
We're gonna let you talk later. I'm sorry.
250,000 customers?
Subject to check.
Subject to check. Thank you, attorney. You're not my attorney, I guess.
Commissioners, do you have any questions of Mr. Moore? Mr. Slater, you have any questions of Mr. Moore?
Yeah, actually, yes, I do. Since he's under oath, and I didn't get to ask this question of Mr. Davis, and I'm sorry to put you on the spot, but...
We want to call Mr. Davis back. He's still here.
No, it's okay. I got somebody under oath. That'll work just fine. But thank you. Mr. Davis, I don't know if you heard, but he made the comment that we send a lot of money out of state for RECs, or SRECs, to be more specific. Can you tell me, in the last 2 auctions, have there been out-of-state bids?
I believe it was 3 years ago that we had out-of-state bids.
So there haven't been in the last 2 years, but yet prices have decreased. Am I right?
No. So it was 3 years ago that, if I'm not mistaken, in North Carolina. 2 years ago. 2 years ago? So it was 2 years.
Well, again, now I have somebody else answering that I don't get to ask questions of. But back to my point, for the last 2 years, you have not had out-of-state bidders.
In the long-term auction? In the auction
SREC
process.
auction.
Yeah. I can't remember if it was 2 or 3 years ago that it was the last time we had somebody.
I will confirm that it's the last 2 years.
Okay.
3 years ago you did, 2 years ago, the last 2 years you have not. But presumably Delmarva also knows what the percentages are today. Is that right? For the cost of compliance?
Not to my knowledge. We provide information to DENREC for calculations, but I have not done a calculation. I don't know if anybody in Delmarva has done an actual calculation. It's not part of the responsibility, so I have not. I have not done a calculation. Under oath.
I have one more question. So lower prices of SREC is good for consumers, is that right?
Yes.
Actually, I have one more. When you have an auction, that auction is not a one-year contract, but is indeed a 20-year contract, is that correct?
That is correct.
Thank you.
Mr. Myers, you've been moving a lot over there.
Have a casual clothes on, that's why. A couple just quick responses to a couple of different things. One, the freeze doesn't end the program. I mean, you can still spend money on to meet the requirements, you just can't spend above the statutory percentages. Two, DP&L comes in, to my understanding, in February or March with an estimate of its compliance costs for the year, because they want to charge customers on the bottom of their bill what their compliance charges are. So they can estimate it, and I assume they can estimate how much revenue they're going to take in during the year. So during the year, they know, they could easily calculate, it seems to me, whether they're over any of the cost cap percentages. And forewarn everybody, or stop buying over the percentages. But those are sort of collateral points. My main point is, what you've heard throughout this is an argument against the statute, not against your rules. They can't live with what the statutory requirements and caps are. As I said before, put aside all your rules. Take DENRECs, they're still above. They can't live with them. The market, if you adopted DENREC's rules, would face the same kind of problems. DENREC would have to make, in collaboration with you, a freeze decision. It's not going to go away by postponing it a year.
Mr. Slater?
I just really strenuously go back to my letter of last night, and let's get some real numbers in the sense of what DP&L supposedly already transmitted to DENREC, and then ask DP&L, Mr. Moore or somebody, to in effect come up with what the numbers would be under DENREC's rules. And you'll see, I'm pretty sure, that you're over the percentage limits in both situations. Once you have those numbers, then you can come back and talk about a freeze, a postponement, a stay. But what you're allowing now is people to rail against the statute. And the problem with a legislative fix is, I'll ask this gentleman, is the pending legislation that Senator McDowell has introduced on July 31st doesn't change the cost caps. He did. He had a bill. He had Senate Bill 181 started it, and it had a year over year that these people want. But the next day, he had a Senate substitute, and he didn't change the cost caps in the Senate substitute. So the presently pending bill doesn't make any changes to the substantive changes to the cost cap language. It makes some editorial changes about director and he's and she's, but it doesn't change the formulas.
Mr. Slater?
Not to point out a procedure, that didn't seem to be aimed at Mr. Moore, who is currently the witness, and he is your witness. But should you choose to excuse him, I would like to be cognizant of the person on the phone and let them go next before it gets to us.
Okay. And we'll hear from staff as well. We're waiting for,
Well, just as far as questioning Mr. Moore,
Yeah, please.
staff just had one clarifying question, and it actually pertains to something that Mr. Myers brought up. The $500,000 figure, that was just a rough estimate that you threw out there. That, correct me if I'm wrong, that is not the delta between a freeze and a non-freeze. That's the delta between conducting the auction and not conducting the auction, or are they one and the same?
No, it's the second. It is it is the cost of conducting the auction at a $25 average cost at the end of the day. You'd have to determine, and I haven't done it, you'd have to determine the percentage increase in solar over that 1 year, and then you can figure out the average cost of that and what that is. And I don't know off the top of my head how many wrecks that represents.
All right, thank you.
Yep.
Mr. Stevenson?
Hello. Just as a point of reference, I did consider becoming a lawyer.
Wise
So,
choice.
There's still time.
I probably used maybe some, not the right word. I would say that what I have referenced as legislative intent is what the commission decided last year when they passed the statute. They were considering what the legislative intent was, and they decided that it was legislative intent that we would actually honor this 3% cost cap. So I'm not trying to recommend what the commission does here, but provide some information and for perhaps some way to move forward. First thing I would, if it's okay, I would like to answer your question about what this will do to the market.
Please.
So what, you may have gotten a note I sent this morning, woke up early here in Arizona and sent a note out. What you will probably see from this is the commission has already written an order for the last auction, the 2019 auction. That is, any contracts that need to be signed for that 2019 auction are going to be signed. Any kind of a freeze would not obviate that order. Similarly, Delaware Power is building about 5 megawatts of solar as part of the settlement for the merger. That would not be affected by a freeze either. So to meet an annual requirement for solar, you need about 5 megawatts of new power. That generates enough SRECs to meet the standard. Right now, way above the renewable portfolio standard, there are something like 15 different utility scale solar projects being considered for the state. Probably you're looking at 15 to 20 megawatts of new solar going on stream in the next year. Way above what we need to meet the rest of the requirements. So the only thing I would see that would be affected by a freeze is there might be a delay in the next SREC auction. Now, as Mr. Moore has said, he's thinking the auction will be March, April, May. Well, that gives the legislature time to address the issue of the cost cap before the next SREC auction. So, if there's going to be a change in the law, it'll probably happen. My concern is that you have a statute that required DENREC to submit information, and they have not done so. So what is your leverage to pry that information out of their stingy land? And what, putting in a temporary freeze until they comply, it would literally mean we would not sign off on the next SREC auction until they comply. Has a minimal impact over the next 4 or 5 months. It would only have an impact if instead of doing an auction in May, it gets done sometime later in the year. The other thing is they keep saying, well, we're going to delay this decision until May 31st. Well, that's not the case because you've got timing issues built into this that you're not going to look at the actual calculation until October. You're not going to make a decision on a freeze to November. We're talking about almost a 1-year delay if you don't do something now. The other issue, we've talked talked a lot about concerns about the solar industry. I haven't heard too much concern about the wind industry, but we hear a lot about solar. But we haven't heard anything, except from Mr. Myers so far, about the ratepayers. Part of the reps of the law in 2010 was to protect the ratepayers, and that has not happened. I was involved in the Bloom tariff. It was advocated by Denrec to have Bloom. 2012, we started installing fuel cells. 2013, Denrec came up with the first proposed regulation. It included, Bloom was going to be included in the calculation at that time. All of the discussions we're having today about interpretations of these laws were held from the public comments that were made in 2013. We had a legislative session in 2013. Denrec did not go and get anything done. 2014, the second proposed regulation came in. It also included Bloom. We had a legislative session in 2014. Denrec did not go to try to get the law changed. 2015, we had the third iteration of the proposed regulation. Bloom was still included, and there was another legislative session. Denrec did not go for any change in the law. Finally, 2016, we have a fourth iteration of the regulation, and Denrec, now for this one, took Bloom out of it for the first time in the last, at the last moment, we had gone through quite a few iterations of public comment on it, and the final regulation came out without Bloom. They did a calculation, and that calculation showed that we were over the 1% and we were over 3%, but there was no freeze. So, no, then we get into all the legal debates of the last several years. So here we are, 2010 law, first proposed regulation 2013, and here it is 2019, and we've never had a calculation that has taken the ratepayer into account. We're probably, educated guess, we're probably somewhere between 12 and 14% using the statute that is currently on the books. So when do we take the ratepayers' concerns in here? So, and then just one other point, quick one. If the legislature is going to consider this, it would be helpful for the legislature to have had a calculation so that they know where we stand versus the 3%. And you can do the calculation using Denrec's proposal, and you can do the calculation based on the statute, and that would provide valuable information for the legislature in deciding how to change the regulation. So no matter what we do, we need to do this calculation. And I think the only leverage the commission has is to say, we're not going to approve the next SREC auction until you provide this information. It's not a legal opinion, it's a suggestion. So with that, I will turn it back over to you folks.
Thank you, Mr. Stevenson. Mr. Slater?
Would you prefer that I go first or staff? It's up to you.
I think I said Mr. Slater.
Sure. Thank you.
Thank you.
Thank you, Mr. Chairman and Commissioners. I've tried to be as quiet as possible. It's difficult sometimes. So I'll start off. I thought the only thing before you today is what to do about Denrec's apparent violation of the regulations. But it actually goes further than that. What are you going to do, or what can you do about the apparent violation of the statute? Because your regulations have a deadline. The statute is what actually says, hey, Denrec, you have to do a calculation. So I'll begin there. On February 23rd of 2016, the Denrec Division of Energy and Climate came before you. And they stated, we understand that there are parties who have appealed that regulation, which was the regulations that they had promulgated that Judge LeGros subsequently found were not lawful. We understand that there are parties who have appealed that regulation and DENREC's authorities under the statute. That appeal will take its course over the next several months or longer, perhaps. However, we have a job to do under that statute and the regulations as promulgated, and DENREC intends to move forward with our responsibilities, which is what brings us here today. That is the one and only time they've come before you with a calculation, February 23rd of 2016. And they fulfilled their responsibilities at that point in time. That was 1,381 days ago. 119,318,400 seconds. 1,988,000. Go ahead, sorry. 1,988,640 minutes ago. 33,144 hours ago. As I said, 1,381 days ago. 197 weeks and 2 days ago. 378.36% of a common year ago. And, you know, I've done that before. I've brought it up before. Some have found that funny. But let me tell you what's not funny. The millions of dollars Delmarva Power has spent to procure renewable energy and ratepayers have paid since that singular day, February 23rd of 2016, where our sister agency provided a calculation. That's not funny. Millions of dollars, last year it was north of $68 million, have been spent with no calculation, no consultation, no decision on discretion. That's the statute. That's not your regulations. It's the statute. I take the responsibility of my office, ratepayer advocacy, and the statute to heart. It's one of the great honors that I have to be appointed by the governor and unanimously confirmed by the Senate. And I've always tried to follow the rules and take guidance and listen to my superiors and listen to anybody else that's willing to talk. Indeed, you know, I know that I am not perfect, but this is the fourth time our fellow state agency has mentioned a stay of your regulations. They first made mention of a stay in their initial appeal of your decision to the Superior Court after opposing our intervention, which was denied based on our statutory authority to appear before the court. They filed a motion requesting a stay. They then sent a letter, which is still pending. They then sent a letter to the court asking for a stay of the litigation and regulations portraying that as the status quo. And the court denied that petition. And now, before you, an eerily similar argument already denied by the court. They're here asking for a stay of your final regulations that are, I believe, are otherwise outside of your control as they are before the court and have already been made final. You have an awesome responsibility to balance the need of the utility and their ratepayers, their captive customers. Again, in 2016, the calculations were provided. That was the statute says you have to, there are 4 points to this, right? You do a calculation, you have a consultation, you make a determination, and then you move forward with auctions. But you can't not follow the statute on the first three and just say year after year, we're going to continue to increase rates on customers. That's not fair to them. In reading through DENREC's letter, I found a statement that if Bloom is included, a freeze will remain for the next 12 years. As I had asked Mr. Moore, how long are the contracts? The contracts are 20 years. We don't know whether or not there will be a freeze. And quite honestly, I didn't think today was going to be about whether or not there would be a freeze. I thought it was about what do you do about the fact that a cost cap has not, or a calculation has not been provided as per the statute. But let me just mention ratepayers for a second. If you sign 20-year contracts, and as DENREC's own letter says, it could be frozen for 12 years or more, ratepayers are, again, on the hook for the cost. Not Delmarva, because they pass it on to the ratepayers. Not DENREC, not the state, no one else. I won't go back into substantive details on our comments. You know, I don't think that we should rehash the argument that's currently before the Superior Court. But I will comment on Bloom since that was mentioned, and I would prefer not to talk about it. When Bloom was placed on bills of the captive Delmarva Power customers for, quote, green jobs and economic development, there was no provision providing a clawback of those funds if the green jobs didn't materialize. This should be a warning now and well into the future that placing green jobs and economic development on captive utility customers, which disproportionately affects the low income as a form of regressive taxation. They pay the same amount that I do, based on their usage, which may be significantly more. They may actually pay a lot more than I do, should be prohibited. DENREC's letter states that the November 13th deadline is not, quote, essential. I find that absolutely appalling. The deadline was extended to November 13th at the request of the court. The court acknowledged the deadline of November 13th at the November 12th oral argument. And Mr. Chairman, you were fortunate enough to attend with us. The court did not ask for another extension. The court knew very well that it was due the next day and said they would come forward shortly. But to say that your deadline isn't essential, which is in the regulations, I just can't believe that was in writing. Your deadlines are essential. You have rules, procedural schedules, orders, and regulations. I would never think to say that your deadlines aren't essential. I believe that as the chairman has stated at a previous meeting, that you would support a legislative solution. I think you said 1,000%. I too would support a legislative solution, as I think we all would, because none of us want to be in this position. But keep in mind, DENREC appealed you. You're the defendant. We all want a legislative solution. But as has been pointed out, and I looked this morning to see if anything had changed, there's nothing pending in the legislature that changes anything that's on appeal right now. It doesn't resolve this. We all want that. But nothing actually resolves it. But the court has already denied the request for a stay that DENREC is advocating for. I don't believe that you should take up a similar request. But let me go. DENREC has said many times over, as is stated in their letter, that there is a legislative solution. If there's a legislative solution, withdraw your appeal. It's quite simple. Why are you wasting the state's resources and the court's time? If you have a legislative solution, then move forward. We can all join together and hold hands, and I'll build the daggone bridge if you have a legislative solution. But why are we wasting the state's resources and the court's time if you say you have a legislative solution already? But that hasn't happened. And I've heard you mention that you want the litigation to end. None of us want to go to court. I don't find it particularly fun myself. But DENREC appealed your decision. If there's a legislative solution, then we should move forward with a legislative solution, and they should withdraw their appeal. I've already kind of mentioned my runner's analogy. You start at the starting line and you finish at the finish line. You have to start with the calculation. That's not your regulations. That's the statute. And if we continue on to not perform a calculation because we don't want to, again, the last time it was done was February 23rd, 2016. I won't give you all the minutes and seconds again. Then the precedent that you set is pretty astounding. I believe in a level playing field. I also try and put myself in other people's shoes. to understand, you know, to understand what would happen if I made this argument. And I am certain that if I said your deadlines, rules, procedures, any other actions you take are not essential, I am absolutely certain that your hearing examiners, that you, that perhaps others would chastise me, and rightfully so. You should, because you are essential, you are important, you are in the statute, you have an awesome responsibility. But if you agree with their argument for a stay, I think you set an amazing precedent. Again, I'll go back to the only thing before you is what do you do about DENREC not performing the cost cap, which is set in the statute.
What are you suggesting?
I suggest that if DENREC is unwilling to provide the number, then you request Mr. Moore or Delmarva Power provide you with the number and perform the cost cap calculation and move forward. Because at the end of the day, the only people here who are truly harmed are the ratepayers who have to pay the final bill. DENREC isn't harmed. Delmarva isn't harmed. They're the only ones that are actually harmed at the end of the day because they have to pay this final bill. You know, we talk about going forward with another auction or Delmarva Power may have to purchase more RECs. But again, you haven't done the fundamental steps to get to a point to determine whether or not there's a freeze. And I'm not saying, I mean, you can't even get to that point, but the statute requires it. Yet you continue to, you know, allegedly move up in compliance years. The last time that you had a number before you was compliance year 2014. That was February 23rd of 2016. I suggest that the numbers be presented and that you have to move forward. And by the way, I haven't actually talked to Ms. Iori about anything I've said today, which is kind of terrifying. But by the way, if the court decides, even if the court granted a stay, the calculations still due. It's the statute. It's not just your regulations. It's the law. And there is nothing in the law that allows us to just not do it. If somebody came to me and said, you know, hey, we think that you have to do this. First of all, I'd say thank you. But I'd also talk to my attorney and figure out, is that true? And if so, then I have to comply, right? Because it's not you giving them a directive. It's not me giving them a directive. It's the General Assembly. You know, the executive branch doesn't make the laws. The judicial branch doesn't make the laws. It's only the legislative branch. The legislative branch clearly said that you have to do a calculation. We don't have anything. So how do we keep going up and spending more ratepayer money when we haven't done the fundamental steps to get there? Thank you.
Thank you, Mr. Slater. Mr. O'Brien?
Thank you, Chairman and Commissioners. Bill O'Brien on behalf of staff for this proceeding. Staff's position is that the commission has a regulation in effect right now. There's no debate about that. There is a deadline which was postponed earlier to it was October 14th. It's been postponed by the commission to November 13th. We do know that DENREC has not submitted the calculations that are required by that deadline in our effective regulation right now. So we do think that it's appropriate to discuss what to do about that apparent violation of our existing regulation. We do know that you have before you a request from DENREC to again delay that deadline They've asked for May 31st. Their reasoning is the pending legislation that they assert is in the works. They've also mentioned in their letter that the reasoning behind the first extension was that the Superior Court asked for that extension so that they could answer DENREC's motion to stay the regulation prior to us moving forward with that part of our regulation. We agreed that was appropriate at the time, and the commission granted that 30-day extension. So DENREC mentioned that in their letter also. Staff does not object to a further postponement of that deadline, again, for the same reason that the Superior Court asked for it for the first time, which is to allow the Superior Court to answer the question of whether DENREC's regulations are stayed during the litigation that we have in Superior Court. We think that that would provide deference to the Superior Court and their authority over whether the regulations are stayed. We think that would provide some level of certainty, at least in the short term, because if we do go forward with the freeze process and then the regulation itself is stayed, then we would have gone forward on that. It would be mooted. The reason behind that would be mooted. So we do think it's appropriate to wait until the motion to stay is acted upon by the Superior Court. But at this time, we wouldn't go as far as supporting an extension all the way till May 31st. At this time, anyway, we don't think that pending legislation is a rational basis for essentially suspending a regulation, at least at this time.
Chairman, I don't want to interrupt you, but just on behalf of the commission, I, at the appropriate time, would like to just set forth some very basic points before a motion is set forth. I think are some important wrap-up points which give a clear view of the picture and the
Good.
request.
We'll get your input at that time. Mr. Tweedy?
Thank you, Chair Winslow. So, numerous times it has been stated that DENREC can't live with the statute. That is utterly incorrect. DENREC is repeatedly referring back to the statute. The statute is what we want to live by. The statute provides discretion to DENREC under I and J. It's the Commission's regulations that have taken that discretion away by requiring us to submit a calculation. Nothing in the statute says DENREC needs to submit a calculation. By saying that the Commission can overrule DENREC's decision, nothing in the statute provides that. DENREC is entirely happy with the statute. We think that the statute could be improved. It's many years old. It's in need of updating. But to say that we can't live with the statute is completely false. We do have problems with the regulations. That's why we've challenged them in court through the appropriate mechanism. I think it's very noteworthy, yet again, that the focus has been on what DENREC should apparently do under I and J, according to the public advocate, Mr. Myers and Mr. Stevenson. Nowhere has it been referenced the Commission's authority to do the exact things or similar things that they want to force DENREC to do. DENREC has discretion under I and J, and DENREC has exercised its discretion not to implement a freeze. The Commission has authority to slow or accelerate the RPS percentages. The Commission has also exercised its discretion not to do so, and never once, either today or to my knowledge previously, have the public advocate, Mr. Myers and Mr. Stevenson, challenged that approach. It's very noteworthy that this is the way they are attacking this. Several times the requests for stays in the Superior Court were referenced. To be clear, the DENREC's motion to stay implementation of the regulations continues to pend, as Mr. O'Brien indicated. That is still outstanding. That was the rationale for the stay that has already been granted.
Your Honor, there is no stay at this time. I should clarify for the record.
I'm not aware of any stay.
The stay motion is still pending.
Oh, okay.
If I misstated, I'm sorry. The stay motion is still pending before the court.
Right, and there's no stay unless it's granted.
So a final point I wanted to touch on is that the importance of stability was mentioned earlier. That is exactly what DENREC is seeking, that the scheduled percentages that are in the statute are what is implemented, that a freeze not be put in place. We heard earlier that Delmarva is already halfway through its compliance year and has been operating as if it is in the current compliance year, not a frozen compliance year. Stability is what DENREC wants. We also heard Mr. Davies talk about the stability that REPSA provides to the solar industry in Delaware and the importance of REPSA and the increasing percentages to that industry. I think it was Mr. Slater who stated that DENREC, something to the order of, quote, have to do this. We have to do these calculations. We have to provide these calculations. If that is his interpretation of 354I and J, which again provide that DENREC may freeze the percentages, then that same interpretation would apply to 354C and D that provide the commission with discretion to accelerate or slow. If one is mandatory under some interpretation that is totally contrary to any statutory interpretation I understand, then the same would apply to those other provisions. That is not what he is asserting for some entirely inconsistent reason I do not understand. And the last thing I will just touch on is that Mr. Myers and others again suggest something to the effect of if DENREC's version of the calculation were adopted, then DENREC's version of the calculation was not adopted by the commission. That is a hypothetical that we are not living under. So it's sort of hard to imagine how that would even proceed. I think that's all I have. Thank you for your time.
Thank you, sir.
Mr. Chairman, when you're...
Well, I think we've heard from all the parties, and we've had a little bit of rebuttal from Mr. Tweedy. Are we ready to hear from Mr. Walsh, or do you have something?
Mr. Chairman, I'm glad to defer to Mr. Walsh as long as
Well,
I can
once we
get a second.
get to Mr. Walsh, we're going to be over with. So I'd like to...
Well, then if I may, just have a quick moment. Mr. Tweedy began by saying, everybody's attacking him, and, that's, or DENREC, and that's just not, DENREC brought this lawsuit. No one is attacking DENREC. They brought the lawsuit, but I and J say they have to do the calculation. They haven't done the calculation. What my point is that you can't do A, B, and C, or not do the calculation, not have a consultation, and not then make a determination, but continue to increase the RPS. You have to do all of the steps. And what I hear is, we're not going to do the calculation. But if there's a legislative solution, then drop the appeal. I'll just...
Mr. Myers,
2 minutes?
go ahead, Mr. Myers.
In the mic, please.
In the microphone.
Light down.
If you adopt staff's recommendation, why not give us the numbers? Why don't you make the numbers public? If they don't want to do it, get DP&L to give you the numbers they
Okay, we've heard that argument already.
It doesn't make any sense not to do it.
Well, sometimes I guess DENREC would argue we don't make sense, but Mr. Moore, you're not a party here. We can't call on you. Ms. Iwari would get upset with me. She's already upset.
Not that has mattered before, Chairman Winslow.
Well, we try to be as inclusive as possible here, Ms. Iwari, Mr. Walsh.
Thank you, Chairman, Commissioners. I have 6 points here, and they're short, but they're very important. And in the commission's decision today, I want to point these out because I think it's vital. There have been a lot of facts, a lot of testimony, some sworn, some not. But let's go back to the agenda, which I think has a telling point on its. So this is regular agenda item 3. And under A, it says, Commission to consider action regarding DENREC's apparent violation of 26 Dell Admin Code Section 3008-3.2.21.5. That, of course, is the submission of the calculations. If that had read the statute and not the administrative code, I wonder if DENREC would concede all arguments because, as DENREC has said, the statute controls. But I think they would not. Point 1, again, DENREC says the statute controls. Forget about the regulations. We disagree with them. So notwithstanding 29 Dell Code Section 10144, which states, unless the court issues a stay, regulations, enforcement of such regulations may be stayed only by the court. There's also a dearth of case law that says an agency has an obligation to enforce its regulations. If the agency doesn't enforce its own regulations, who will? I know DENREC is very good at enforcing its own regulations, as it should be. So, statute but no regs. And the statute is unequivocal. Despite what DENREC may have stated to you, let's not lose sight of how we got back here. Judge LeGros' opinion of almost 3 years ago, December 30th, 2016, she stated very simply, look, 362 says the PSC drafts the regulations and does everything it needs to promulgate and put into effect REPSA. DENREC does the calculations and then sends them to the commission, and in consultation with the commission, and it goes forth. So we can end right there. That's the end of it. So DENREC has a statutory obligation to submit the calculations. 3, again, the regs are not stayed. They wouldn't have filed a motion to stay second, maybe a third time, according to the judge, if they thought they could just unilaterally stay the regulations. That letter request, which was heard recently, was denied. There is no stay. DENREC's disagreement with the regs does not equal stay. Again, that's just they've elected to create that under the idea of there's no decision yet. Well, I just read to you the statute that says if there's not a decision, they're in effect. That's the law. They say the statute controls, well, the APA controls too. Then it says that this commission can't, via the regulations, tell DENREC when to submit the calculations. Yet, let's consider this dichotomy here. Commission can't, by its regulations, tell DENREC when to submit the calculations. But DENREC is here and believes this commission can say, we can't, well, how about if we just tell you May 31st, or May 30th, was it May 31st, 2020? Well, you can tell us that. I think that's what they're saying. You can't tell us under what the regs say, but you can tell us May 31st if you want. We'd go with those regs. Well, that is basically bootstrapping the statutory obligation and throwing it out the window, which Mr. Myers pointed out in his papers very correctly, is unconstitutional. This commission can't just throw away its own statutory obligations, let alone another agency's obligations. So that just it can't stand, it doesn't pass muster under any decision-making. So we end up with the argument, again, about the administration, which is mentioned as a capitalized term, again, in their most recent letter that brings us here today. The administration's mentioned 5 times, and we've heard enough about that. Whatever that may be, it is a may be. We're dealing today with what is. There is a statute in place. There are regulations in place that are not stayed, and we are here to consider the fact, nobody disputes that they have violated the regulation. Whether they disagree with it, if I disagree with the speed limit on the way back, I suppose I could, no offense to Mr. Moore, I could still tell the state trooper, listen, no ticket for me, I disagree with it ought to be 75 here. I don't think that's the way it works. And if the agency is going to stand by its obligation to enforce regulations, then let's look at the plain letter of what those regulations are. Whether it's past due, it is. Is it stayed? It is not. What do you want to do about it? That's all I got. Thanks.
Thank you, Mr. Walsh. Mr. Tweedy, with respect to the calculation, knowing that you all have great skill at math over at your office, if we were to request that you provide us with those calculations, how long would it take you to get those calculations to us? Recognizing that you don't have any authority, obviously, to make any commitments, but what is your best judgment with respect to timing?
I personally do not know the answer to that, Chair.
Well, you can consult with Ms. Cobb if you'd like to. And you can just tell me you're not going to give me, if you're not going to give me a figure, that's perfectly fine too. Just don't give me a figure. Just say I can't do that.
I think the conclusion is that I cannot offer
Okay.
that.
Okay, no problem.
Sorry, can I please hear the answer?
I cannot offer that date. I cannot offer to submit that.
Okay.
I don't have that authority.
Perhaps the commission could offer a date.
Well, let me just make a few comments. First of all, Ms. Cobb, I hope that this whole hearing has been illuminating for you in terms of how we do our business.
Indeed.
So, I mean, we try to hear every side that we could, but I'll be very frank with you. Having heard everybody talk today, I think that Mr. Walsh probably made the best comment very up front, which was, we've heard all these legal arguments, and so we heard them all again. We heard them for 2.5 hours again. I really, frankly, what I wanted to know was what impact are our consumers, on our marketplace, et cetera. No one seemed to want to pick up on that too much. But we don't, sometimes just the the letter of the law looks like it might be somewhat plain, but you have to understand what's going on, how that law is affecting other people. And we've heard something about it today. We heard about, of course, we heard about the stability issue. We heard about the number of people employed in the state of Delaware. We heard about, the businesses, prices for SRECs going down. We heard about how much it costs within some reasonable estimation each consumer. And we have a market. We have just things going on, and what this commission does or does not do adversely impacts that marketplace. And my feeling, I'm just talking out loud. This is what we do, Mrs. Cobb. We just talk out loud and we express ourselves, and if they disagree, they'll say something, and then we'll try to talk it out and come to some sort of agreement. Maybe our own lawyer might not like it, but we'll come to an agreement, I think. So my thinking on it is, I mean, okay, so let's say we put it off until the judge makes the decision, and the judge makes a decision on February the 6th, 2020. Well, what are we winning by that? How much are we gaining by that? We still have a litigation ongoing. We still have a fight. Now we're in the legislature, so we can fight in the legislature too, because we're not going to agree with what DENREC's going to propose, perhaps. Hopefully we will. I intend that we do, because I don't want this argument anymore. But I have it, so we have to decide it. So, and I don't find a request to take this issue, which is very, very troubling, and it has very, you know, you look at the arguments of the parties, and they have one definition for may, and Gary corrects them. I think he corrects them on the may plus the discretion word. We may not give you as much discretion as you think you have, let's put it that way. So I think what I'm looking at it is from sort of a practical way. It's not going to cost the consumer much more money on a monthly basis for us to put this thing off until May 31st, 2020. It's going to give all the parties a chance to get what they want in legislation and change it. This thing is just a mess. It's a Gordian knot. It's a gift that keeps giving, and we don't want to get the gift anymore. It's a sick Christmas present we have right here. So that's the way I think about it, and I just want my fellow commissioners to express themselves if they want to, and let's see where this thing's going to go.
My feeling is that we ask DENREC to comply with the existing statutory terms and produce their calculations now or by January 15th, and allow the legislature to make the corrections as per the statute in their own time, as per the administration's desire.
My feelings are the same also, that DENREC should comply with whatever the regs and the statute and everything is, as Mr. Walsh and Ms. Ivory has mentioned, and submit us the calculations. Then what? January, May, June, legislature, anyone, let the process take place, but we need the calculations. Thank you.
My position is that I agree that it starts with the calculations. You know, I keep reading over Section 354 I&J and understanding that the freeze may be put in place, but it is in consultation with the commission. And that consultation can't take place without those calculations, in my opinion. And so I will agree with Commissioner Conaway that we make a deadline for the calculations of January 15th. I think it's appropriate. Nothing's going to go forward without those calculations. A freeze, practically speaking, may or may not take place. Of course, you know, we all need to take into consideration the industry, but you know, without those calculations, nothing seems to be going forward. And understanding that there is litigation in process, it is again in process, and we can still comply, that date notwithstanding. And that's my position as well.
I'll start by saying there's no doubt about the value and benefits of renewable energy, our environment, health, and the future grid. But likewise, we can't manage what we don't measure. And so it seems to me that DENREC is standing in the way of measuring or managing the situation. It feels for me like Groundhog Day. I've been here before. I haven't been here a long time, but I've been here with this topic before. We need the DENREC metrics and calculations, then we can decide how to proceed. I'd like to circle back to something I think I heard Mr. Tweedy say, and I hope I get this right. I heard you say that DENREC has the authority and the discretion to implement a freeze. So the PSC wants to fulfill our statutory obligations, receiving the calculations from DENREC. DENREC can then assert that stated authority and discretion to either implement or reject a freeze. That's how I see it. I agree with my colleagues, and we should have these calculations by mid-January.
Commissioner Drexler and Commissioner Gray, how do you feel about we're going to, I believe we will, in agreement, we should set a date with respect to the submission of the figures. But what are we going to do about, what is your position with respect to the legislative time?
When you say the legislative time,
The date that we're going to give them? what date?
January 15, I think, is the date that I heard,
Okay.
for the calculations to come forward.
Someone please make a motion. Commissioner.
All right, I will move that we ask DENREC to comply with existing statutory terms and produce the calculations by January 15th. And also allow the legislature to make corrections in their time as per the administration's desire.
I second it.
Okay, time for some discussion. Commissioner Gray. Did you have something?
I just want to be clear on one aspect of your motion. I think I heard you say, let the legislature make their changes according to their timeframe.
Yes.
So that is
We
not
keep
bounding
hearing
them by
about the
January 15th.
legislative corrections, so let them make them.
Right, but that's not bound to the January 15th
No.
date. Okay.
No.
What is the motion intending with respect to the date given for the legislature to consider?
I don't think that I have the option to tell the legislature when they have to make the decision.
For a point of discussion, Mr. Chair, the way I see it, my view, is if the legislature takes, first of all, if we receive the calculations on January 15th, then we schedule, according to our regulations, the next decisions that we need to make in collaborations with DENREC. If either the court and/or the legislature intervenes to give us additional guidance and directives, then we follow those accordingly.
Want to make a comment for the record? Or not? Talk about you. Okay, so restate the motion, please.
That we ask DENREC to comply with the existing statutory terms and produce calculations by January 15th. At that point, the legislature and/or the court will make the decision when the legislature has to make corrections as per the administration's desire.
Point
Does
of
that make sense?
Point of clarification.
Okay.
I think you had said, when you were responding to Chairman Winslow, that we can't,
That's
meaning the
correct,
commission,
yes,
can't tell the legislature when you want something by, and you can't do that with the court either. So I'm not sure that you really need that second part of your motion.
All right, fine. Then we'll allow the legislature to make corrections in their own time as per the administration's desire.
Does that need, can that be excluded from can your
Sure.
motion simply
We just
say,
want comply with
ask
existing statutory
DENREC to
terms
provide?
and produce calculations by January 15th. And we'll go forth from there.
Yes.
I second.
Okay, so,
Yeah,
Yeah, I second it.
It was a new motion.
yeah.
And
okay, so
Commissioner,
let me, Mr. Walsh, go ahead, please.
you did reference statutory terms, and I just want to
Yes,
clarify
comply
that
with existing statutory terms.
regulation.
You want regulatory? I thought it was the statute that called for.
Regulation.
Well, the statute calls for
Well,
it too,
both.
and several of us argued that.
Okay, statutory and regulatory
Statutory and regulatory terms.
terms for submitting the calculations.
Okay.
Okay, so.
You want to go over again?
Yeah,
Read it again?
let's do it one more time.
Okay, we'll try it once more.
Third is charm.
I move that we ask DENREC to comply with existing statutory and regulatory terms and produce the calculations by January the 15th.
Okay, now,
Second it.
any discussion? I have a couple of comments. One is that, well, what is intended by the motion? In other words, we have a motion that says they're going to provide the information, which they should already have provided us by January 15th. Obviously, they could do it a lot sooner than that, but they're going to give it to us. If they do give it to us, they're going to give it to us on January the 15th, because then they're going to schedule the consultation with the Public Service Commission on April the 14th, and the consultation is going to go on for a couple of months, and/or someone's going to file a petition in court for mandamus, and we're going to do all kinds of things are going to happen, perhaps. So I'm just sort of putting out there that I think that the cleaner way to do it is just order that they provide the calculation, and let's make a time of May 31st to get it done. If it's not done, then whatever the court rules, and
Chairman,
it's over with.
the motion, respectfully, Commissioner Conaway made the motion, and I think there was a second.
Yes.
And then I think with that, it's, Commissioner Korea, it should be up for vote.
It's point of order.
I think we can have a discussion before we vote, can't we, Tom?
Point of order, Mr. Chair. Typically, a motion comes and gets seconded. It is a discussion for a vote on that motion, unless you're offering a friendly amendment to Commissioner Conaway.
I was just offering some comments which I thought were pertinent with respect to her motion and in discussion of the motion. And I rule that I'm in order. So, okay, the motion, all those in favor of the motion signify by saying aye.
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 All those opposed? Abstaining is me.
Mr. Chair?
Yes, sir.
I would like to ask the Commission's counsel one question before we adjourn.
Well, we're not, okay. We're not adjourning yet. You may want to adjourn right now, but we're not.
Should Mr. Moore be excused?
Sorry, I didn't want to make light of it, but.
Well, his name is Moore. He should be willing to sit for more, no? No, just kidding.
Yeah, thank you very much, Glenn. Thank you so much.
Since we are assembled, and I think you pointed to the agenda that said action required by the commission. So we've just approved a motion to request calculations by January 15. If we don't get those by January 15, are there any other actions today that we need to take on this measure by the agenda that will ensure that they come?
I was just going to say, I don't think we should be having that conversation in front of Denver.
Well, that's suitable response for the advice I have requested. Thank you.
And I would agree with that. There is, if anything has been predictable in any of this, is that it's not predictable, so. But we should all be optimistic notwithstanding.
Mr. Chairman, point of clarification. I'll direct it to Mr. Walsh. The vote that you just took has to be memorialized next week, correct?
Yes, I will have it
December
ready. It's 3:45. I'll have it ready by 3:59.
Thank you, Mr. Walsh. Ms. Nickerson will distribute it.
I'll draft it.
The order we have to sign.
You have to memorialize this order?
Yeah.
What you did verbally?
The motion.
Oh, I see.
I guess that's, the final thank you to Ms. Cobb. Hope you enjoyed yourself. And I know you're not going to want to come back after this experience.
Welcome, Ms. Cobb, and we're really actually pretty friendly people,
We are.
all of us here.
Really.
Yes.
Yes.
And Mr. DiNardo, thank you very much for taking your time and coming over here. Obviously, you've heard enough, and you know that we need that statute changed, and just tell the senator that we appreciate all of his thoughtful work and hard work on this particular issue, and we're looking forward to getting it done.
Yeah, I can guarantee we're working on it.
assume
Wha-
we're adjourned, but I.
No, 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 we're not adjourned.
We're not adjourned.
Whoa. Excuse me,
Is there
folks.
anyone here for
Folks,
public comment?
we're not adjourned.
Guys, people, we're not adjourned yet. Could everybody either sit down or leave?
Is there anyone here for public comment? Oh, yes, go ahead, Chris. Will you speak, Nicholas, please speak directly to Ms. Iori.
I'll keep it real short. I mean, so, you know, today I know we're not here to talk about the freeze. Obviously, it's about the wording within the statute. I just do want to say that the RPS is needed for every citizen in the state and around the country. Climate change is real. You know, I don't even think I have to justify it, but engineers around this country, particularly civils, are planning for it, and it's not for no reason. So the RPS is, you know, the major way that this country has been taking action against it since, you know, we don't see any type of federal response to it. And I think we should maintain our leadership with keeping the RPS, and I just hope it doesn't get frozen, that's all.
Well, we're going to depend upon your leadership in January and February through Senator McDowell.
Of course. Of course.
And may I note that one of my several brothers is a bridge engineer, graduate of University of Delaware, and a great guy. So,
Thank you.
good luck to you.
I appreciate it.
Director's comments.
Thank you, Mr. Chairman. I'm lost. I just want to mention there was supposed to be a customer from Tidewater for public comment. If he or she is not here, we move ahead. Do you know?
So that customer, given the length of today's meeting, it was advised that he's not here today.
That's fine. Thank you. Thank you. Under director's comment, I have a very small administrative item. Before we had circulated the adjusted meeting dates for 2020, which reduces the number of meetings by 4 meetings over the year. We still keep it on Wednesdays, as you had approved earlier, and it'll still be at 1 o'clock. And as Commissioner Gray has suggested, if we need to make adjustments as we go along, we'll do so. So I just need your approval for that calendar.
I move that we adopt the calendar for 2020 as edited.
Any discussion? Hearing none, all in favor? Aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Doctor.
Thank you. Let me see my extensive notes, what else I have today. Oh, no, nothing. That's all, Mr. Chairman.
Thank you all
So-
very much.
So the next meeting is
Yes.
1 week from today, right?
1 week from today.
1 week from today,
Your
right.
material will go out tomorrow.
Thank you.